Good afternoon, everyone. This is the Joint Financial Regulatory Agency's stakeholder meeting to discuss the rule review for home equity lending. My name is Matt Nance, and I'm the Office of Consumer Credit Commissioner's Deputy General Counsel. I'm joined by several members of the Finance Agency's staff, including Credit Union Commissioner John Kohlhoff, Consumer Credit Commissioner Leslie Pettyjohn, the Department of Banking's Senior Counsel Everett Jobe, Department of Savings and Mortgage Lending's Associate General Counsel Ian Berry, and the OCCC's Senior Paralegal Ginger Harmon, who's acting as our meeting organizer. We are holding this meeting online through GoToWebinar. Normally, we like to hold these stakeholder meetings both in person and online, but like everyone, we are, of course, following developments with the coronavirus and COVID-19. And to help promote everyone's safety, the Finance Commission building is currently closed to the public. We thought that holding this webinar would be a good way to be transparent in our rulemaking while also being safe, and I look forward to the next time I can see you all in person. I want to thank everyone for joining this webinar. We've had a lot of interest in this particular webinar. I'm really pleased to see that. We currently have 93 attendees. I sent out an email yesterday that we have an attendee limit of 101. So I'm hoping that doesn't inhibit anyone's ability to see this webinar. We will be posting a recording of it online, and I'll be sending out an email with a link to that. That'll also be posted on the OCCC's webpage for recent and upcoming rules. But again, I really appreciate all the interest in this. Getting input from stakeholders is a really important part of the rulemaking process, and these meetings help us make sure we produce the best interpretations possible. Now, some of you might be listening on your phones, some may be watching on your computers, some may be doing both. For those of you watching on your computer, there's a window where you can submit questions. If you have technical questions about using the webinar, you can type them in and Ginger will try to answer those. If you have any comments on the notice itself, go ahead and type those in at any time and we'll be getting to those as well. And if you're on a computer with a mic and you'd like to make a verbal comment, there's a button on your control panel with a hand and a green arrow. If you push that, that signals that you're raising your hand and wish to make a verbal comment. As attendees, you should currently be muted, but I'd encourage you to make sure you're currently muted until you wish to make a comment. So we're talking about home equity interpretation amendments that are coming out of a process called rule review. The Texas Government Code requires state agencies to review their rules every 4 years to make sure they should still exist and to make any necessary updates. And when we do that, we try to get input from stakeholders on whether the rules should be updated. The interpretations currently up for review govern home equity lending and are in Texas Administrative Code, Title VII, Chapters 151 through 153. And we've released an informal pre-comment draft of amendments that are currently up for receiving informal comment from stakeholders. Our plan is to later propose those to our oversight bodies, the Credit Union Commission and the Finance Commission. I'd like to first summarize our draft amendments and then lay out the proposed timeline, and then you'll have a chance to provide comments. So coming out of rule review, we have 7 sections with proposed changes in Chapter 151, as well as 7 sections in Chapter 153. The changes in Chapter 151 have to do with the procedures for requesting, proposing, and adopting home equity interpretations. Currently, Chapter 151 lays out a process where stakeholders can submit a request for an interpretation and describes some of the procedures that the Finance Commission and Credit Union Commission use to propose and adopt them. Rule review gives us a chance to take a fresh look at these rules, and when we took a look at the procedures as a work group, we noticed 3 things. First, the procedure for requesting interpretations in current sections 151.1 through 3 hasn't been commonly used by stakeholders. Most of our feedback from stakeholders has come from informal comments as a result of constitutional amendments, litigation, or rule review. Second, we noticed that the Finance Commission and Credit Union Commission already have separate rules on formal petitions for rulemaking, tracking the requirements of the Texas Administrative Procedure Act, or APA. The request procedure in sections 151.1 through 3 has some, but not all, of those petition requirements, making it a kind of hybrid or semi-formal procedure between informal requests and formal petitions for review. And third, we noticed that 151.4 through 7 includes some, but not all, of the rulemaking requirements from the APA for proposing and adopting rules. In our pre-comment draft, we're proposing to address these issues in two ways. First, as to the process for requesting interpretations, we'd remove language in 151.1 through 3 on the hybrid process and replace it with two provisions: a statement that a stakeholder can informally request an interpretation, and a statement that a stakeholder can provide a formal petition for review, with citations to the rules that lay out the requirements for those formal petitions. This would help explain that stakeholders can file informal requests, which is how we normally get requests, while also preserving the right to file a rulemaking petition. The right to file those petitions is an important statutory right. It's related to the First Amendment right to petition the government, and it's certainly something we want to preserve by specifying an appropriate process for filing a petition. We think these amendments would appropriately preserve both of those ways of requesting interpretations. Second, we'd replace 151.4 through 7 with a statement that the commissions will propose and adopt interpretations in accordance with the APA's rulemaking requirements. We thought this would be simpler than recreating those requirements piecemeal, and it ensures we don't need to amend Chapter 151 every time the legislature amends the APA. So those are the amendments to Chapter 151. Moving to Chapter 153, we have amendments to the interpretations of the Constitution's home equity provisions. In Section 153.8, there's a list that has an extra word "or," so we'd remove that from that particular list. In Section 153.11, we have an issue that's received a lot of attention lately, including a series of court decisions, starting with the Texas Supreme Court's 2014 decision in Sims versus Carrington Mortgage. Based on these decisions, we propose adding language in 153.11 to explain that the repayment schedule requirements apply at closing and don't prohibit a lender from agreeing with the borrower to certain modifications. And we'd specifically include deferments as one of the types of modifications allowed, similar to what the agencies have explained in advisory bulletins on Hurricane Harvey and the COVID-19 pandemic. In 153.14, we have another issue that's come up in the COVID-19 pandemic, and this time it relates to states of emergency. We explain that when the Constitution talks about a state of emergency declared by the president or governor, that includes a national emergency declared by the president, as well as a state of disaster declared by the governor of Texas. In Section 153.15, we have a third issue that's come up recently, and that's the location for closing a loan. The Constitution has a requirement that the loan has to be closed at the office of a lender, title company, or attorney. And earlier this year, we heard some interest from lenders about closing loans in places where they could maintain social distancing, such as their office parking lot. These amendments explain that the closing can happen at a location at the permanent physical address of the lender, title company, or attorney, again, similar to what we explained in our most recent advisory bulletin. In Section 153.22, we have some language on providing documents, explaining that those can be provided to the borrower electronically in accordance with state and federal law, with citations to the Texas Uniform Electronic Transactions Act and the Federal e-Sign Act. We have a new Section 153.26 on the requirement to sign a written acknowledgement of fair market value. When we sought feedback, we had some interest in this issue, and this new section would explain that the lender may sign the written acknowledgement before or at closing, and that an authorized agent may sign on the lender's behalf. And finally, in Section 153.41, it came to our attention that the introductory paragraph of that section mistakenly includes the phrase "or A7." It seems that this is incorrectly repeating language from Section 50E in the Constitution, so this amendment would correct that. So that's the summary of our pre-comment draft amendments. Here's a proposed timeline for the amendments. You can see we're at the initial pre-comment stage, and we're requesting informal pre-comments by July 15th. We intend to propose the amendments at the August Credit Union Commission and Finance Commission meetings. There would be an official comment period during the month of September. We'd present the rules for adoption at the Commission's October and November meetings, and the amendments would be effective in late November. This is a tentative timeline, and of course, all interpretation amendments are subject to final approval by the commissions. And if any stakeholders think a different timeline is appropriate, we'd be interested in that feedback. So with that, I've summarized our pre-comment draft of amendments, and I'd like to open it up for comments on any of these amendments. Our webinar notice, which is available on the OCCC's recent and upcoming rules webpage if you click on Home Equity Rule Review. So the webinar notice on pages 2 and 3 lists questions we're interested in getting feedback on, including whether the amendments to Chapter 151 would provide appropriate methods to request interpretations, whether the proposed amendments are appropriate and consistent with the Constitution, whether the interpretations appropriately address issues arising from the COVID-19 pandemic, whether stakeholders recommend additional text, and what costs and benefits stakeholders will experience. Or if there are any other issues, we'd welcome comments on those. Now, I will say if you're planning to recommend additional text, it would be really helpful for us if you could explain what the text you're suggesting adding is and what constitutional provision would be interpreted, as well as how the recommendation would help stakeholders. That would help us understand the legal and factual basis for the feedback. Again, there are 2 ways to provide your feedback through this webinar. First, you can type your comment out and send it to us through the webinar's question feature, or if you're on a computer with a mic, there should be a function allowing you to raise your hand by clicking a button on the control panel for GoToWebinar with a hand and a green arrow on it. And if you have technical questions, you can type those into the chat at any time. Ginger, do we have any written questions or comments through the webinar? Okay, I'm standing by. May have some questions coming in. Okay, we have a hand raised from Karen Neely. Ginger, if you could unmute Ms. Neely and yeah, and you can go ahead and share your comment.
Okay. Yeah, thanks for unmuting. In pre comments, IBAT, TBA, Texas Mortgage Bankers, and the Credit Union League had submitted a couple of additional items, and that included delivery of the cure notice. We've seen some problems where the cure notices are being dumped and then they get lost, and therefore the 60-day period gets missed. This is more where there is an outside servicer, although there are some other issues that have come up there. So that's a new item that we suggest could be helpfully addressed. And another one that we've seen come up through litigation is release of lien. And we believe that filing, recording the release of lien should be considered satisfaction. One of the issues that pops up is with MERS and sale of loans. There's some real difficulty in getting an original note returned. This was easy in the old days when you just had one lender who had the notes in a vault someplace, but now our vault is electronic. So recordation of the release, we think, should be satisfactory in that area. And so those are a couple of issues. And then the whole problem of the owner and the collateral in the context of duplexes and some other kinds of property, we think could be fruitfully addressed as well. And we're happy to flesh this out further, but we did want to make sure that they were on your radar screen, as it were. Thanks.
Yeah. thank you for those comments, Karen. I did have a couple of follow-up questions, if that's all right. And if you have an answer now, that's good. If you want to kind of consider these questions for the pre-comment, that's fine too. But regarding the delivery of the cure notice, in our current interpretation at 153.93F, we currently say if the borrower opts for a location or method of delivery other than set out in subsection E, the borrower has the burden of proving that the location and method of delivery were reasonably calculated to put the lender or holder on notice of the default. Are you seeing abuse of that, where a borrower is delivering it to some other strange location? And if you're seeing that, is that current provision sufficient to address that? Or do you have an additional suggestion about language to add?
Apparently, it is still an issue, and it is more of an issue, as I said, for the lenders that have servicers or who sell their loans, et cetera. And so we can come up with some recommended tweaks to the language. The dilemma is that the delivery starts the 60-day notice, and then by the time it's found and the matter is in court, it simply looks as though the lender has just blown off the opportunity to cure, when that's not the fact at all. So we will respond with some tweaks that we think could help in that area. Thank you.
Okay. And regarding the release of lien, I was just going to follow up on that. And so the Constitution says that the lender must cancel and return the note and give the owner a release of lien. And I just want to make sure I'm understanding what you're saying. Are you saying that notice of the release of lien should be considered sufficient to satisfy the requirement to return the note and to release the lien?
Yes, because currently, of course, the Constitution doesn't require recordation, merely delivery of the release. So if we have an actual recordation of the release of the lien, then we would ask that that be considered de facto delivery of the instrument, because it has no further force and effect at that point in time. And it's just a practical issue, because so often these are electronic, and it's difficult, if not impossible, to find a quote original document. So it's a real problem in today's electronic world.
Okay, what I'm wondering about is, would that interpretation give meaning to the whole clause, right, that says return the note and release the lien? If by just releasing the lien, are you really returning the note and releasing the lien? So I'm interested in an analysis of like how we give effect to that language.
Yeah, and that is in fact the dilemma, that by recordation of the release, it would be essentially equivalent to a return of the note when we're dealing with digital instruments. And if we could amend the Constitution easily, that would be the better way. But that's the problem that we're facing, and so that's our solution, is to make the recordation, as opposed to merely delivery, but the recordation of the release, the equivalent of return of the instrument.
Okay. Well, yeah, we're interested in hearing an analysis of, again, how what the interpretation should be, what text that interpretation is based on, and how that interpretation would help stakeholders in practice. And then, yeah, as to the questions about who is the owner and what is the extent of the homestead in kind of novel or difficult situations with duplexes or those kinds of factual situations. Again, I'm interested in what can an interpretation do to address that. What could the text of the interpretation be, and what would the basis for that text be? Or are these just, an interpretation can't necessarily resolve every factually difficult situation.
No, it can't.
But, I'm certainly open to looking at what you've got and considering that. But as to those points, those would be, if, go ahead, provide those in your pre-comment, and those are kind of the points I'd be interested in seeing the analysis of.
Great, thank you.
Okay. Okay, thanks, Karen. Okay, we have some written questions. Okay, first question from Lisa Bowden. On 153.26, will an electronic lender signature work on the FMV document, as well as a few other documents that need a lender signature? So we do address kind of electronic disclosure requirements in our copies of documents section. We have not addressed that in the new 153.26. We could certainly talk about that if any stakeholders have proposed text on electronic signatures for 153.26. I'd be interested to hear that. I think kind of an underlying assumption with all of these documents is that they can be signed electronically if you're doing that in accordance with state and federal law, the Texas Uniform Electronic Transactions Act and the Federal e-Sign Act. And so, yeah, we haven't addressed that in the current text. If there are ideas about the best way to address that, we'd be interested in hearing that feedback. Question from Alan Hansford. Can you repeat your comment regarding electronic forms? Yes, I can repeat that. And remember, the recording of this webinar will be posted later, but that was a brief comment on, in section 153.22, we have some language on providing documents explaining that those can be provided to the borrower electronically in accordance with state and federal law, with citations to the Texas Uniform Electronic Transactions Act and the Federal e-Sign Act. Question from Gene Erickson. Could you share again the proposed effective date of the changes? I believe you said November, but I didn't get the day. I didn't give a specific date. I anticipate it would be late November. Again, this is this is assuming that the Finance Commission and Credit Union Commission propose and adopt these amendments at their August and October and November meetings. And the effective date is connected to the date that we are able to submit the rules to the Texas Register following adoption. And so I don't know exactly what date that's going to be, but I anticipate it'll be a date somewhere in late November, possibly around November 26th or so. But again, contingent on the commission's voting to propose and adopt the amendments, and contingent on our ability to get them to the Texas Register. That's going to determine the exact date. That it'll be around late November. I don't know an exact day yet, since it's contingent on a few things. Okay, question from Michael Baird. For the acknowledgement of fair market value, why limit lender's signature to before or at closing? Does this mean the lender could not sign the FMV acknowledgement the day after closing? I'd be interested in feedback from stakeholders if Yeah, do stakeholders think that document could be signed after closing and still satisfy all the requirements of Section 50A6? And we can take another close look at the text, but again, if stakeholders want to suggest some additional text on that they believe would comply with the Constitution, and there might be some more general language above about like when the loan is made or whether it's made on the condition that so yeah, I'd be interested in hearing stakeholder feedback on that and whether that would comply with that particular provision. Okay. We had some follow-up on the question about electronic documents, clarifying that that was assuming the borrower consented to electronic documents. Yeah, so again, I'm interested in feedback from stakeholders about electronic documents, what amendments are appropriate, and how we can appropriately cite the requirements in state and federal law. Okay, we have a hand raised from Rob Wisner. So Ginger, you can go ahead and unmute Mr. Wisner. Oh, we do not have audio available from Mr. Wisner. I'll give him just a couple minutes to see if he can use the audio drop-down menu to like select a mic. Sometimes that can cause issues with the audio. Okay, Rob, it seems like we're having trouble getting your audio connected. If you wanted to type any comments into the chat function, we could take a look at those and I could try to address those. Okay. Okay, looks like Rob is listening from his phone and is kind of directing us to written comments. So anyway, sorry about the mistake. Again, to use the raise hand feature, you need to either be on a computer with a mic or like a smartphone using the app. Okay, so sorry about that. We will refer to Rob's written comments. Any other hands raised or questions from the chat? Standing by. Looks like we may have more. Oh, also, if you have a longer comment to type into the chat, you can go ahead and send a short message to Ginger just saying, I have a longer question I need to type, and we can stand by and wait for you to type out the longer question. Okay, it looks like we don't have any more questions or hands raised at this time. I did want to wait one more minute, one full minute, just to see if anyone has any other questions or would like to raise a hand. Again, if you have a longer question, you can type in just a short message to Ginger to wait for a couple minutes for you to type in the longer question. But I'll go ahead and wait a full minute starting now, just to make sure no one has any other questions or hands raised. Okay, looks like we don't have any further comments or hands raised.
I'm sorry, Matt. This is Ginger, the organizer. I do have a couple more questions coming in.
Oh, okay. Okay. Well, I'll let you forward those. Okay. Looks like we may have had some questions, but they were withdrawn. Okay, so with that, I have summarized our pre-comment draft of the amendments, and we've heard from stakeholders. Move to our last slide. I want to thank everyone for joining us and participating. Again, I'm really excited that we got so much interest in this webinar. Our rule updates, as with all OCCC rules and these home equity interpretation amendments, the updates are available on the OCCC's webpage for recent and upcoming rules. We'll also be posting the audio of this meeting, and when we do that, we'll have a link to the, we'll post a link on the OCCC rules webpage. We are accepting written pre-comments on the amendments until 5 p.m. next Wednesday, July 15th. Please email those comments to me at rule.comments@occc.texas.gov. Thank you all for attending. Please be safe out there. Take care of yourselves. Take care of each other. And we will see you next time. Thank you.